the landmark case of the Salvation Army v. Social Security System, the central issue revolved around whether religious ministers and officers of the Salvation Army should be classified as employees subject to mandatory Social Security System (SSS) coverage. The organization argued that its ministers are spiritual workers, focusing on ecclesiastical duties rather than economic activities. It claimed that these roles should be considered voluntary or self-employed, not regular employment. However, the Social Security Commission disagreed, pointing out that the relationship between the organization and its ministers showed signs of an employer-employee dynamic. This set the stage for a legal battle that would test the boundaries between religious freedom and labor law. Court of Appeals reviewed the case and upheld the Social Security Commission's decision. It found that the Salvation Army exercised significant control and supervision over its ministers and officers. These individuals were not only performing spiritual duties, but also took on administrative, managerial, and operational tasks. The court noted that these functions extended beyond purely religious work, indicating that the ministers were, in fact, employees under the law. This finding was crucial because it meant that the organization could not simply classify its workers as self-employed or voluntary members to avoid mandatory SSS coverage. The legal reasoning focused on the actual work performed, not just the religious titles held. Supreme Court affirmed the decisions of both the Court of Appeals and the Social Security Commission. It clarified that mandatory SSS coverage does not infringe on religious freedom, as the law targets the secular aspects of employment, not religious doctrine or worship. Court emphasized that religious institutions are not exempt from labor and social legislation when their workers perform tasks that meet the fourfold test of employment: selection and engagement, payment of wages, power of dismissal, and control over work. Since the Salvation Army's ministers were found to be under the organization's control and performed a range of non-religious functions, they were deemed employees for purposes of the Social Security Act. This decision underscores the principle that religious organizations must comply with labor laws when their staff fulfill roles similar to those in secular employment.